State can't make everywhere a sensitive place. You can't go hiking in some places and not be able to defend yourself against somebody that you run into.
Major ruling involving the Second Amendment
will allow scrutiny for all gun laws pertaining to everything: assault weapons, age restrictions, restrictions on magazines.
As the nation deals with a recent wave of mass shootings, the Supreme Court expanded gun rights.
The majority of the court ruling the Constitution protects a person's right to carry a gun outside the home.
A Supreme Court ruling just flipped the entire game on gun laws across America, and the shockwaves are still spreading faster than most people realize. And what makes this decision genuinely explosive is how 6 justices didn't just tweak a policy, but demolished a control system that decided who deserves self-defense rights for over 100 years, where the instant that verdict landed, permit systems in multiple states went into free fall. What makes this transformation extraordinarily significant is how New York's gatekeeping shattered, while California's approval stranglehold broke, and Hawaii transformed from denying nearly everyone to drowning in applications. Why this wasn't legal fine-tuning, but a direct strike at how states controlled your constitutional rights. How the legal battle that tore this framework apart began with 2 New York residents, Robert Nash and Brandon Koch, who wanted something reasonable, which was the right to protect themselves beyond their property, where they followed every procedure the state demanded, completing firearms training and clearing background screenings and maintaining spotless records. But officials rejected them, not because these men posed danger, but because they couldn't demonstrate proper cause, meaning they hadn't proven their lives were threatened enough. And the reason that response was New York's standard procedure under a law enforced for over a century, where a select group of administrators held unlimited discretion to determine whose safety mattered with no transparent criteria, just subjective decisions. Once you understand why, when the Supreme Court issued its decision in New York State Rifle and Pistol Association versus Bruen, it struck with immediate force, where 6 justices voted to overturn New York's system, with Justice Clarence Thomas delivering the majority opinion, stating the Second Amendment secures your right to carry firearms outside your home for self-defense, where it's not a benefit officials distribute selectively or something you must justify based on danger levels. How for over a century, 6 states maintained may-issue frameworks where New York and California and Hawaii and Maryland and Massachusetts and New Jersey granted local officials complete authority to reject permits based on subjective assessments, with the Supreme Court declaring this entire model unconstitutional, and what it means that the court established a new constitutional standard challenging gun restrictions nationwide, where any government seeking to limit your right to carry must now demonstrate that the restriction aligns with America's historical tradition of firearm regulation from the founding period or Reconstruction era, with no more relying on contemporary safety statistics and no more vague protection arguments. You'll realize when this decision took effect, state licensing systems experienced something officials never anticipated, where the barriers maintained for generations suddenly vanished, with Hawaii demonstrating the most dramatic example, going from issuing fewer than 200 concealed carry permits to ordinary residents total for decades to being swamped by thousands of applications within months, while California experienced even more intense pressure, with counties approving dozens of permits annually getting buried under thousands of new applications. A Supreme Court ruling just flipped the entire game on gun laws across America, and the shockwaves are still spreading faster than most people realize. 6 justices didn't just tweak a policy, they demolished a control system that decided who deserves self-defense rights for over 100 years. The instant that verdict landed, permit systems in multiple states went into free fall. New York's gatekeeping shattered, California's approval stranglehold broke, Hawaii transformed from denying nearly everyone to drowning in applications. This wasn't legal fine-tuning. This was a direct strike at how states controlled your constitutional rights. The legal battle that tore this framework apart began with 2 New York residents who wanted something reasonable: the right to protect themselves beyond their property. Robert Nash and Brandon Koch followed every procedure the state demanded. They completed firearms training, cleared background screenings, and maintained spotless records. They simply requested concealed carry permits for basic self-defense. Officials rejected them, not because these men posed danger, but because they couldn't demonstrate proper cause, meaning they hadn't proven their lives were threatened enough. That response was New York's standard procedure under a law enforced for over a century. A select group of administrators held unlimited discretion to determine whose safety mattered. No transparent criteria, just subjective decisions. Nash and Koch rejected this arbitrary system. Alongside the New York State Rifle and Pistol Association, they launched a challenge that climbed to the nation's highest court and dismantled permit frameworks across 6 states. When the Supreme Court issued its decision in New York State Rifle and Pistol Association versus Bruen, it struck with immediate force. 6 justices voted to overturn New York's system, with Justice Clarence Thomas delivering the majority opinion. The Second Amendment secures your right to carry firearms outside your home for self-defense. It's not a benefit officials distribute selectively or something you must justify based on danger levels. For over a century, 6 states maintained may-issue frameworks where New York, California, Hawaii, Maryland, Massachusetts, and New Jersey granted local officials complete authority to reject permits based on subjective assessments. The Supreme Court declared this entire model unconstitutional, but the decision went further. The court established a new constitutional standard that would challenge gun restrictions nationwide. Any government seeking to limit your right to carry must now demonstrate that the restriction aligns with America's historical tradition of firearm regulation from the founding period or Reconstruction era. No more relying on contemporary safety statistics, no more vague protection arguments. The power dynamic reversed instantly. States operating under may-issue systems for generations watched their legal authority evaporate. The Supreme Court created a constitutional test that's destroying gun restrictions at unprecedented rates. Federal judges nationwide can no longer accept modern policy reasoning to uphold firearm regulations. Contemporary crime data is irrelevant. Public opinion doesn't matter. Arguments about community safety get dismissed. Every gun restriction must answer one specific historical question. Did comparable regulations exist when the Second Amendment was ratified in 1791 or during Reconstruction? If no historical precedent exists from 150 years ago, that restriction stands on weak constitutional ground. States flood federal courtrooms with extensive arguments filled with modern safety justifications, only to watch judges reject them entirely. Nothing counts unless states can identify similar regulations from the late 1700s or mid-1800s. Federal courts have already begun striking down significant laws because states cannot produce historical evidence. California lost its prohibition on gun shows at county facilities. Illinois faces serious challenges defending its assault weapons ban. Age restrictions on purchasing handguns are being questioned. Magazine capacity limits face constitutional vulnerabilities. The litigation burden completely flipped. Gun owners spent decades proving laws violated their rights while states cited safety and prevailed. Now states desperately search through centuries-old records trying to justify restrictions they've defended without challenge. Most restrictions cannot survive this scrutiny. States constructed gun control systems based on modern arguments, and this decision removed the entire foundation. When this decision took effect, state licensing systems experienced something officials never anticipated. The barriers maintained for generations suddenly vanished, and the resulting surge overwhelmed infrastructures designed to process minimal volume. Hawaii demonstrates the most dramatic example. For decades, the state issued fewer than 200 concealed carry permits to ordinary residents total. Then Bruen landed. Within months, thousands of Hawaii residents who'd been systematically excluded began submitting applications. The state went from handling single-digit monthly requests to being swamped by thousands. California experienced even more intense pressure. Counties approving dozens of permits annually got buried under thousands of new applications. Los Angeles County saw applications explode within months. Processing timelines extended from weeks to 6 months or longer. Counties hired additional personnel just to prevent system collapse. New Jersey jumped from roughly 1,000 permits yearly to tens of thousands of requests. Background check systems slowed dramatically. What began as a courtroom victory transformed into an ongoing administrative crisis, still overwhelming state bureaucracies. While the Supreme Court destroyed may-issue systems, certain states immediately began constructing replacement obstacles. They deployed location restrictions and administrative requirements that appear reasonable but make legal carrying extraordinarily difficult. New York responded most aggressively. Within months, legislators passed laws making their strategy obvious. If proper cause requirements are unconstitutional, we'll create so many restrictions that permits become practically worthless. The legislation declared enormous portions of the state off-limits for concealed carry. Government buildings, schools, parks, mass transit, houses of worship without permission, entertainment venues, Times Square, and even private property by default unless owners post permission signs that almost no businesses display. Requirements didn't stop there. Applicants must surrender social media accounts for official review. Multiple character references are mandatory. 16 hours of classroom instruction plus 2 hours of live fire training are required. In-person interviews with licensing officers who can question anything. The message was clear. We'll make obtaining and using permits so expensive, invasive, and legally risky that many people will quit. California adopted similar tactics with expanded sensitive place lists, new costly training mandates, and local authority to establish prohibited zones. This wasn't states accepting the Supreme Court's authority. This was calculated resistance disguised as reasonable regulation. Behind concealed carry permits sits a massive financial system most people never consider. Training facilities, certified instructors, processing centers, and licensing departments built substantial revenue streams around strict requirements over decades. California residents regularly paid hundreds for mandatory training before applying. Maryland generated millions annually through similar mandates. New York's new requirements cost applicants $200 or more just for classroom portions. This ecosystem generates over $1 billion nationally every year. But federal courts are now questioning whether expensive mandatory requirements create unconstitutional barriers excluding people who lack hundreds of spare dollars. They're applying the same historical test. Did similar financial requirements exist during the founding period? Almost certainly not. If judges determine these costs make rights too expensive for average citizens, the structure profiting from restricted rights for decades could collapse rapidly. Legal challenges to these requirements are advancing through federal courts right now. The Bruen decision created a powerful legal framework now being deployed against virtually every gun restriction nationwide. Over 300 active federal cases are currently challenging various laws under this new historical standard. Multiple suits target laws preventing adults under 21 from purchasing handguns, arguing young adults owned firearms during the founding period. States with assault weapons bans face major constitutional challenges as they struggle to prove restrictions match anything from the 1700s or 1800s. Cases challenge long waiting periods, questioning whether founding-era precedent exists. Even New York's post-Bruen sensitive place restrictions face federal challenges. What distinguishes this moment is genuine momentum. Gun rights organizations view Bruen as the breakthrough they've anticipated for decades. Restrictions seeming politically untouchable years ago are now vulnerable. Many cases are advancing through federal appeals and could reach the Supreme Court again soon. For gun owners, this directly impacts what you can do right now. If you live in former May-issue states, you finally have genuine paths to concealed carry permits without proving special danger or enduring arbitrary delays. New York cannot deny you for lacking proper cause. California sheriffs cannot reject applications based on subjective judgments. If you pass background checks, complete training, and have no disqualifying history, you can obtain permits. But states that lost May-issue authority fought back with new complications. You must understand what your state implemented since this ruling: expanded sensitive place lists, new expensive training mandates, social media reviews. Reality varies dramatically by location. Where you can actually carry varies enormously. Some states allow carrying almost everywhere except obvious locations. Others created complicated patchworks of restrictions. Know your state's current laws thoroughly. Understand which locations are prohibited. One Supreme Court decision completely restructured Second Amendment constitutional frameworks and sent shockwaves through every state. As governments adapt and over 300 challenges advance through courts, this transformation continues accelerating. That's it for today, folks. See you in the next video.